Good afternoon, everybody. Hello, ACS. All right. Hello. I'm Tino Cuellar, a member of the ACS National Board of Directors and of the Bay Area Lawyer Chapter Board of Advisors. And this is Jill Dash, the marvelous, dynamic ACS Director of Lawyer Chapters. Ladies and gentlemen, every year throughout the world, people wait in suspense to learn some important facts. Who will win the Nobel Peace Prize? The Oscar for Best Picture, and in ascending order of importance, of course, the ACS Awards for the top lawyer chapters in the country. In fact, we're delighted to see you today because we get to honor the achievements of some of our top lawyer chapters around the country. As you may know, ACS now has almost 40 lawyer chapters, from Boston to San Diego, from Austin to Montana. That number is growing. If there is not a lawyer chapter in your city, please consider that the ACS board will offer you a new car and your law school loans paid. Well, I think I'll get in trouble with Caroline for that one. But in any event, we're happy to help you get one started.
I've helped facilitate several lawyer chapters. Where's my car? The first Lawyer Chapter Award is for commitment to diversity. This year's Diversity Award goes to our Minneapolis St. Paul Lawyer Chapter. Which, in addition to having a fabulous and diverse group of leaders, has worked diligently to put on programming that truly represents the many facets of its community. Their same-sex marriage program featured, among others, the Minnesota same-sex marriage legislation's author, Senator Scott Dibble, and a packed audience, not surprisingly. They also recently hosted Minnesota Supreme Court Justice Alan Page, the first African-American elected to that state's Supreme Court, who also happens to be a member of the Pro Football Hall of Fame. Our second award is the Networking Award for the chapter with the highest percentage increase in membership over the past year. This year, the award goes to the Oregon Lawyer Chapter. The Oregon Lawyer Chapter has seen a more than 67% growth in membership since last year's convention. That's no accident because they have held dozens of programs in the last year, including their annual dinner this year honoring former Oregon Governor Barbara Roberts and featuring Judge Diane Wood of the 7th Circuit. And now.
Our last award is for Lawyer Chapter of the Year. This award goes to the chapter that has shown the greatest overall strength in meeting ACS's mission and goals. This year's award goes to the Georgia Lawyer Chapter. Congratulations. In the last year alone, the Georgia chapter has had programming on stand your ground laws, environmental litigation, voting rights, same-sex marriage, the right to counsel, both criminal and civil, the constitutionality of the filibuster, and drone strikes. 2 of those programs were on C-SPAN, which for the 6 or 7 of us who watch C-SPAN around the country, is a really, really great thing. On top of that, they held their 6th annual public interest holiday happy hour and a fundraiser just last month. And students take note, the current co-chairs, Sarah Turing and Matt Weiss, as well as many members of the Georgia Lawyer Chapter Executive Board, are former ACS student leaders. This is what we mean when we say ACS for life, just to be clear. For all these reasons, it's our pleasure to name the Georgia Lawyer Chapter our Lawyer Chapter of the Year. Please join us in congratulating our awardees. And now it's my pleasure and honor to turn the stage back over to our rock star president, Caroline Frederickson.
Well, Tino, I don't know if you know your audience all that well, because I would suspect that there are a few people in this room who watch C-SPAN. And I think that's a good thing. Don't feel bad about that. We know who you are. So I get tasked with a lot of the best things. I guess that's what you get when you're president. And I get to give out now the second Progressive Champion Award of 2013. And this year, in addition to John Lewis, who we heard from this morning, and I just have to reflect again on how incredible that speech was, and how wonderful the plenary that succeeded it really was in filling out some of the vision that John Lewis spelled out for us this morning. But we are also proud to recognize Brad Smith as a 2013 Progressive Champion. And Brad is Microsoft's General Counsel and Executive Vice President. He leads the company's Department of Legal and Corporate Affairs, which has approximately 1,100 employees located in 55 countries, and is responsible for the company's legal work, its intellectual property portfolio and patent licensing business, and its government affairs and philanthropic work. Brad is also the Microsoft senior executive responsible for the company's corporate citizenship and philanthropic work, including a multi-billion-dollar company-wide commitment to creating opportunities for 300 million youth around the world over the next 3 years. But Brad has done more than that. He's also helped advance several significant diversity initiatives within the broader legal profession by using business incentives such as bonuses to law firms that achieve various benchmarks. And as an added commitment, Brad and other senior Microsoft leaders only receive their year-end merit bonus if at least 75% of the utilized law firms receive their diversity bonus. But I think what's particularly relevant in this room and in some of the topics we're going to discuss this afternoon about representing those most in need, Brad was a co-founder and currently co-chairs the board of directors of Kids in Need of Defense, or KIND, a pro bono organization dedicated to providing legal representation to the thousands of unaccompanied immigrant and refugee children in the United States who face deportation hearings. Brad has helped bring together law firms, corporations, NGOs, universities, and volunteers to provide quality and compassionate legal counsel to these otherwise defenseless children. He's also the chair-elect of the Leadership Council on Legal Diversity and has advanced several education and philanthropic initiatives. So ACS is honored to recognize Brad Smith and Microsoft as a 2013 Progressive Champion. Now, unfortunately, Brad could not be with us today because he's out somewhere protecting kittens and baby birds and doing other good things. So here to accept the award on his behalf is an old friend of mine. We've spent a number of years together in the Senate, and it's a pleasure to see him here representing Microsoft, and that's Charlie Salem, who is Microsoft's Managing Director of Public Policy.
Thank you, Caroline. I'll admit to being actually a C-SPAN 2 junkie, but that's another story. Thank you so much, Caroline, for that introduction and for talking about some of the things that we at Microsoft hold very dear in terms of the work that we're able to do and that Brad Smith is able to lead for us. He wanted me to extend his thanks to you and to the folks at ACS for this award and his deep regret that he couldn't be here today. Carolyn talked about some of the things that Brad has been working on and has really championed throughout his time at Microsoft, and I just wanted to talk a little bit more about the issue that Carolyn raised, Kids in Need of Defense, and that's KIND. This is an organization that Brad co-founded. He talked about doing some work on this, thought about finding the sort of most obscure co-founder, and that was Angelina Jolie. So we have a lot of firepower behind this initiative. It's a very serious issue, and it's something that we take as a point of personal pride in terms of our involvement. Kind provides training and supervision to volunteer lawyers. They work in an area that is incredibly difficult, and that is with immigrant children who are facing deportation proceedings without a parent or adult guardian. Over the last 5 years, Kind has grown significantly, and our involvement in that has been something that we are very proud of. Kind has partnered with over 150 major law firms and companies. We've provided more than $30 million in pro bono hours representing these kids, and they've trained more than 5,000 attorneys who are now part of a national pool of lawyers with the skills needed to represent undocumented kids in immigration court. But the need in this area, unfortunately, is growing. Children are coming to the United States in record numbers. Just to give you kind of a sense of the growth pattern, in 2011, just under 7,000 kids were placed in U.S. custody and put into deportation proceedings. In 2012, that number nearly doubled. And in 2013, the projection is that anywhere from 24,000 to 26,000 kids will be in this circumstance. So Brad wouldn't want me to miss this opportunity with such a big collection of lawyers in the room to do some recruiting for Kind. So I'll give you a quick pitch on that. You don't need to be a litigator. You don't need to have specific immigration law experience. The training programs are fantastic. I've gone through it myself, as have a number of folks in our office. But you really get something important out of this, and that is helping an unaccompanied child through one of the most difficult and potentially life-changing court proceedings that they'll face. So if any of you are interested in working in this area, I encourage you to go to www.supportkind.org, and they'll get you signed up and started on this really worthwhile program. So I don't want to spend a lot of time going through the other things that were mentioned here about Brad's service in the pro bono area, and I know we're all looking forward to an exciting program ahead. So I'll just close saying that I wanted to thank ACS and Caroline, my friend from our days in the Senate, for recognizing us. I feel proud and humbled to be working for a general counsel who cares about this and a company that cares about helping some of the least fortunate among us. So on behalf of Brad and the company, thank you, Caroline and ACS, for this honor.
Wow, what a great crowd. Good afternoon. I'm honored to have the opportunity to introduce to you this afternoon Justice John Paul Stevens. Justice Stevens is a remarkable jurist. He's also a remarkable man. I had the opportunity to work for him for 1 year, and I'm fond of telling people about my experiences that year, that he's the sort of man that even if he had been the proprietor of a service station, rather than the Justice of the United States Supreme Court, I would have been just as proud to work for him and would have been just as enriched by his intellect, his professionalism, his love for this country and its Constitution, his sense of fairness, his devotion to liberty, his gentle sense of humor, and his humility. This is the 11th annual convention of the American Constitution Society, and it reflects the 11th year that we have asked Justice Stevens to address this convention. In fairness, for many of those years, he's been a little busy in June, this time of year, but we are especially grateful that he's accepted our invitation this year. And we are pleased that he is joined today by a couple of members of his family, his granddaughter, Hannah, his son-in-law, Kevin, and his current law clerk, Ed. It's well known that Justice Stevens was appointed to the Supreme Court by President Ford in 1975, and that he left the court in 2010 as his longest serving of the then justices, 34 years, 6 months, and 11 days, taking his place in history as the third longest serving justice. Before his death, President Ford said that the appointment of Justice Stevens was one of the greatest acts of his presidency. But let me share with you a few lesser-known facts about Justice Stevens. He was born in Chicago. He grew up in Hyde Park, Illinois, the son of an entrepreneur and an English teacher. He is a sportsman. He's a skilled player of tennis and golf, and I confirmed with him just a few minutes ago that his golf game is going pretty well. I asked him how he was playing. He said he wished I'd asked him the question a week ago when he would have said great instead of this week when he would have said terribly. But that's the way golf goes. He's also a sports fan. As a child, he became loyal to the Chicago Cubs, and that loyalty continues till today. He would tell you that one of the greatest moments of his life was when he had the opportunity to throw out the first pitch in a Cubs versus Reds game, and the ball sailed right over home plate. He is a war hero. After graduating from the University of Chicago and before attending Northwestern School of Law, he served as a naval intelligence officer in World War II, receiving the Bronze Star for his work in breaking code in the Pacific Theater. Perhaps having successfully broken Japanese war code, law school was a piece of cake. And certainly that's the evidence, since he graduated from Northwestern School of Law with the highest GPA in that school's history. After leaving law school, he became a distinguished scholar and private practitioner in the area of antitrust law, teaching antitrust law at both Northwestern and the University of Chicago School of Law, and serving as special counsel to the House of Representatives. He's also a great bridge player, achieving the distinction of Silver Life Master of Bridge, a title of rare accomplishment, especially for someone who can only play in tournaments a few days a year. His memory and work productivity are formidable, and he is a prolific writer. Even before he began his judicial career as a member of the Seventh Circuit, he had published at least 7 law review articles on antitrust law. As a member of the federal bench, he has authored more than 2,000 opinions. And in the first year of retirement, just for diversion, he wrote a book of memoirs called The Five Chiefs, in which he captures his memories on working of the court through his personal experiences with 5 of its chief justices. It's a great read, and I commend it to all of you. Justice Stevens is also a patriot and a guardian of liberty. Having served this country in war, he has special regard for what this nation stands for. In Texas v. Johnson, he famously dissented from the court's striking of a Texas statute barring the desecration of the flag, saying a country's flag is a symbol of more than nationhood and national unity. The American flag is more than a proud symbol of the courage, determination, and gifts of nature that transformed 13 fledgling colonies into a world power. It is a symbol of freedom, of equal opportunity, of religious tolerance, and of goodwill. Referring to that religious tolerance and writing just as powerfully for liberty, but this time from the other side of the First Amendment coin, and thankfully in the majority this time, he wrote in Wallace v. Jaffrey, a case striking down a required minute of silence in schools, that just as the right to speak and the right to refrain from speaking are complementary components of a broader concept of individual freedom of mind, so also the individual's freedom to choose his own creed is the counterpart of his right to refrain from accepting the creed of the majority. The individual freedom of conscience, protected by the First Amendment, embraces the right to select any religious faith, or none at all. Justice Stevens is resolute and brave, going without fear or restraint where the facts and the law lead him, with no ambition to tilt the scale to suit his ends or to incline future decisions to his personal pleasure or preferences. This resoluteness was first put on critical display in 1969 when he served as a counsel to a commission convened to investigate the allegations of corruption against the Illinois Supreme Court. His vigorous pursuit of truth in that investigation led to the resignation of the Chief Justice and another former Chief Justice of that court, and ultimately led to President Nixon's decision to appoint him to the Seventh Circuit. Finally, it bears noting that Justice Stevens has proven a conundrum for constitutional scholars who have debated whether he should be characterized as a conservative or a liberal. there's a drive in constitutional scholarships to try to find lines of ideology that might allow the successful to predict how he will decide a particular case or type of case. True to his days in naval intelligence, however, Justice Stevens has approached each case as an analyst, seeking to review and understand the facts and law of each case and to receive the views of his colleagues before coming to rest on a decision. This analytical case-by-case approach has made it difficult to successfully characterize Justice Stevens. It may be that Justice Stevens faces history as an enigma and constantly defies characterization. I believe, though, that his record of dedicated and faithful service to the rule of law, rather than to any particular ideology, will force us to create a new category. Not liberal, not conservative, but simply impartial. It is now with great honor that I present to you a faithful and impartial guardian of the rule of law, Justice John Paul Stevens.
Thank you. Thank you very much. Thank you. Thank you. Does this work? Can you hear me? Okay. Well, I hadn't intended to start out this way, but one glaring omission in the introduction, Teresa. I hate to criticize somebody who's been so nice to me, but you failed to mention one of my real talents, and that is selecting good law clerks. This afternoon, I plan to say a few words about the original Constitution, about an important case interpreting the 14th Amendment, and about the court's recent decision authorizing suspicionless searches for DNA evidence. In the spring of 1986, Warren Burger resigned his position as Chief Justice of the United States because, as chairman of the Commission on the Bicentennial of the Constitution, he was responsible for telling the story of our great constitutional system to the American people, a task that he could not adequately perform while continuing in judicial office. While Thurgood Marshall firmly believed in the importance of the rule of law and the power of the federal judiciary to decide constitutional cases in a way that can make our union more perfect, he did not share Warren Burger's unqualified admiration for the entire Constitution as it was originally drafted. Three imperfections in the original text must have troubled him. First, the prohibition against any regulation of the slave trade prior to 1808, together with the prohibition in Article 5 of any amendment to the Constitution that would have changed that rule. Second, the Fugitive Slave Clause that had been part of Article 4 of the original text until that clause was superseded by the 13th Amendment. And third, the provision in Section 2 of Article 1, providing that 3/5 of the slave population shall be counted for the purpose of determining the size of a state's congressional delegation, as well as the number of its votes for president in the Electoral College. That provision was offensive because it treated every African American as 3/5 of a white person. It was even more offensive, however, because it increased the power of the southern states by counting 3/5 of their slaves for apportionment purposes, even though the slaves were not allowed to vote. The northern states would have been better off if the slave population had been simply omitted from the number used to measure the voting power of the slave states. The significance of the slave bonus has often been overlooked. In 1800, for example, because that bonus then gave the southern states an extra 9 or 10 votes in the Electoral College, and Jefferson prevailed over John Adams by only 8 electoral votes, it determined the outcome of the presidential election. As a result of the slave bonus, Jefferson was elected, and Adams served only 1 term as president. The slave bonus must also have unfairly enhanced the power of the southern states in Congress throughout the period prior to the Civil War. It was after the war that Section 2 of the 14th Amendment put an end to the slave bonus. When the 15th Amendment was ratified during the Grant administration, the size of the southern states' congressional delegations was governed by the number of citizens eligible to vote. Since that number included blacks as well as whites, during the Reconstruction, those states were no longer being overrepresented in either Congress or the Electoral College. During those years, while the South was divided into military districts occupied by federal troops, Southern blacks enthusiastically embraced their newly acquired political freedom. As Professor Gary May has noted, as many as 2,000 served as state legislators, city councilmen, tax assessors, justices of the peace, jurors, sheriffs, and U.S. Marshals. 14 black politicians entered the House of Representatives, and 2 became U.S. senators. After Reconstruction ended, however, the terrorist tactics of the Ku Klux Klan and other groups devoted to the cause of white supremacy effectively prevented any significant voting at all by African Americans, thus replacing a pre-war 3/5 bonus with a post-Reconstruction bonus of nearly 100% of the non-voting African Americans. For almost a century, until the Civil Rights Act was enacted during President Lyndon Johnson's administration, the Southern states' representation in Congress was significantly larger than it should have been. While the unfairness of the underrepresentation of blacks is obvious, I am not sure that the unfairness of the overrepresentation of the white supremacists in the South during that period has been fully appreciated. See if I can find the water. Because there seems to be a consensus among scholars that the slaughterhouse cases were incorrectly decided, and that Justice Miller's opinion for the 5-justice majority in that case was primarily responsible for the court's unfortunately narrow interpretation of the Civil War amendments, I shall briefly explain my disagreement with that consensus. On March 8, 1869, the Louisiana legislature, which was then controlled by Republicans, enacted a law regulating the slaughter of animals for the New Orleans market. In earlier years, the unregulated slaughterhouses located on the banks of the Mississippi River upstream from the city had been a principal cause of pollution that had made New Orleans the most unhealthy large city in the country, with a death rate more than 8 times higher than any comparable American city. The new statute, which was entitled, quote, "An Act to Protect the Health of the City of New Orleans, to locate the stock landings and slaughterhouses, and to incorporate the Crescent City Livestock Landing and Slaughterhouse Company," unquote, granted the new corporation the exclusive right to conduct the livestock landing and slaughterhouse business within a defined area. It imposed a duty on the company to permit any person to use its facilities on terms fixed in the statute. As Justice Miller explained, the statute did not deprive any butchers of the right to exercise their trade or impose upon them any restrictions incompatible with its successful pursuit or furnishing the people of the city with the necessary daily supply of animal food. In essence, the Act created a new regulated monopoly, but there's nothing in the majority or the three dissenting opinions that criticize the way the business was regulated. Moreover, the pre-existing health problems were apparently solved by regulating the location of all slaughterhouses and the way they could operate. The butcher's challenge to the constitutionality of the new statute was rejected by the Louisiana courts. In their appeal to the United States Supreme Court, they were represented by John Campbell, a former member of the court who had joined the court's judgment in the infamous Dred Scott case, and who, after the war started, had resigned to accept a position in the Confederate government. One of the four constitutional arguments that Campbell advanced was the claim that the statute abridged the privileges and immunities of the citizens of the United States. The majority's rejection of that argument has been criticized for drawing a distinction between the privileges and immunities of state citizens on the one hand and those of federal citizens on the other. But whether or not that distinction is valid, the holding that the statutory grant of a monopoly did not abridge the butcher's privilege or immunities because the statute did not prevent them from continuing their work as butchers seems clearly correct. Perhaps the most remarkable part of Campbell's argument, and of each of the three dissenting opinions, as well as most scholarly discussions of the case, is the failure to provide the reader with a precise description of the constitutional privilege at issue. Justice Field, in his dissent, made the interesting argument that, quote, all monopolies in any trade or manufacture are an invasion of a constitutionally protected privilege, for they encroach upon the liberty of citizens to acquire property and pursue happiness, and were held void at common law in the great case of monopolies, decided during the reign of Queen Elizabeth. Perhaps if he had picked up a fifth vote for that argument, there would have been no need to enact the Sherman Act to prohibit the monopolization of interstate commerce. Or if the Elizabethan case of monopolies had involved candlestick makers instead of playing cards, the analogy between the unsuccessful challenge to Louisiana's regulation of butchers in 1869 and the later successful challenge to New York's regulation of bakers upheld in the Lochner case might have been more apparent. Economic regulation of butchers, bakers, and candlestick makers may all be supported by the same rational basis. Indeed, the debate within the five-justice majority in the McDonald case over whether substantive due process or the Privileges and Immunities Clause provided the better rationale for invalidating Chicago's gun control ordinance might have been avoided. While the majority opinion in the Slaughterhouse case is often identified as the principal source of the court's failure to construe the 14th Amendment as generously as its sponsors intended, I am persuaded that another case in which John Campbell represented white supremacists from Louisiana was even more important. In United States against Cruikshank, the Supreme Court set aside the convictions of the only three defendants who had been found guilty among the many participants in the massacre of dozens of African Americans at Colfax, Louisiana, on April 13, 1873. The trial judge in the Cruikshank case was William Burnham Woods, a Fifth Circuit judge who was later appointed to the Supreme Court. He had previously written an important opinion on which lawyers in the Grant administration had relied when they successfully prosecuted members of the Ku Klux Klan for their use of violence to prevent black citizens from voting. After quoting the text of the Equal Protection Clause and the final section of the 14th Amendment authorizing Congress to enact enabling legislation, Judge Wood wrote, quote, from these provisions it follows clearly, as it seems to me, that Congress has the power by appropriate legislation to protect the fundamental rights of citizens of the United States against unfriendly or insufficient state legislation. For the 14th Amendment not only prohibits the making or enforcing of laws which shall abridge the privileges of the citizen, but prohibits the states from denying to all persons within its jurisdiction the equal protection of the laws. Denying includes inaction as well as action, and denying the equal protection of the laws includes the omission to protect as well as the omission to pass laws for the protection of its fundamental rights as well as the enactment of such laws. Under Judge Wood's reading of the Equal Protection Clause as covering state inaction as well as state action, the police would violate the federal law not only when they actively participated in race riots, as they did in New Orleans during the riot of 1872, but also when they merely stood by and watched the Ku Klux Klan massacre blacks, as they did in Memphis in 1866. I think the Supreme Court's erroneous reversal of Judge Wood's rulings in the Cruikshank case and its rejection of his interpretation of the 14th Amendment did much more harm to the new class of citizens than Justice Miller's opinion in the slaughter cases. The title of Charles Lane's excellent book about the Colfax riot, The Day Freedom Died, refers not to the date of the riot, but to March 27, 1876, the date the Cruikshank decision was announced. Last week, in a 5-4 decision, the Supreme Court upheld Maryland's requirement that the police collect a DNA sample from every person charged with a violent crime. The sample that was obtained from the defendant after his arrest for menacing a group of people with a shotgun matched the DNA specimen obtained 10 years ago in an unsolved rape case. The match provided the basis for the defendant's conviction of rape, but the Maryland Court of Appeals set aside his conviction after deciding that the Maryland police had violated the defendant's constitutional rights when they took his DNA sample. In his opinion for the court, reinstating the rape conviction, Justice Kennedy concluded that the procedure, which admittedly constituted a, quote, search, unquote, within the meaning of the Fourth Amendment, was reasonable as a part of the routine identification process followed when taking arrested persons into custody. In his dissenting opinion, Justice Scalia argued that the real purpose for the search was to solve crimes rather than to identify persons that the state had taken into custody, and that the Fourth Amendment categorically forbids searching anyone for evidence of a crime if there is no basis for believing the person is guilty of a crime or is in the possession of incriminating evidence. He colorfully stated that the court's assertion, quote, that DNA is being taken not to solve crimes, but to identify those in the state's custody, taxes the credulity of the credulous. He ended his opinion expressing the, quote, hope that today's incursion on the Fourth Amendment, like an earlier one, will someday be repudiated, unquote. In a footnote to that conclusion, he wrote, quote, compare New York v. Belton, cite, paren, suspicionless search of a car permitted upon the arrest of the driver, close paren, with Arizona v. Gant, cite, quote, paren, on second thought, comma, no, close paren. I particularly enjoyed reading that footnote because I had dissented from Potter Stewart's opinion in the Belton case and was the author of the court opinion in Gant, which Justice Scalia had joined 4 years ago. Reflecting about those cases, however, has persuaded me that even if Justice Scalia has correctly rejected Justice Kennedy's identification justification for taking DNA records from persons arrested for violent felonies, other considerations may well support the majority's holding. First, Unlike evidence that may be obtained by examining the contents of containers and clothing during the search of an automobile, taking a DNA sample reveals no information about the private, non-criminal conduct of the object of the search. In the Belton case, I remember being particularly offended because the majority's rule allowed an arresting officer making a traffic stop to search through the driver's briefcase. It seems to me that taking a DNA sample or a fingerprint sample involves a far lesser intrusion on an ordinary person's privacy than a search that allows an officer to rummage through private papers. Second, the proven accuracy of DNA samples in both establishing guilt and exonerating the innocent who have been mistakenly convicted or accused favors greater rather than lesser use of DNA evidence. Rules that unnecessarily preclude the use of such evidence may impede the search for truth without providing any meaningful protection for privacy interests. In the Maryland case, for example, the only interest in privacy that was implicated was the defendant's interest in not being convicted of a serious crime that he in fact committed. Third, the public interest in creating accurate databases about individuals who are reasonably believed to have been engaged in significant criminal behavior should not be ignored. The Maryland system did not apply indiscriminately to the entire population, but only to those for whom there was probable cause to justify their arrest for a violent crime. It is not entirely accurate to characterize the taking of a DNA sample from members of that class as a, quote, suspicionless search, even though they may not be convicted of any crime. More complete and more accurate databases may be useful, not only for the purpose of solving crimes, but also for the purpose, for example, of identifying persons who should not be permitted to purchase handguns. Fourth, expanding DNA databases will certainly have an increasingly significant deterrent effect on potential rapists. The deterrent value of increasing punishment for crime is always qualified by the criminal's confidence in his ability to avoid detection. But every potential rapist whose DNA is already available to the law enforcement community will surely know that his identity will be known to the police if he commits a race. In sum, although I commend Justice Scalia's characteristically lucid opinion to you, and admittedly have not read the briefs in the case, I think I would have voted with the majority if I were still on the court. Thank you for your attention.
Thank you so much, Justice Stevens. Our 11-year wait was definitely worth it. Thank you so much. We're absolutely honored by having you with us today. Now it's my privilege, and it turns out to be a personal privilege, to introduce the Acting Associate Attorney General of the United States, Tony West. I don't know that Caroline knew in asking me to do this that there's a lot of personal connection. First, though, I want to say that there is news about Tony West's nomination to be the Associate Attorney General. The acting is one step closer to being removed from his title. The Judiciary Committee reported his nomination to the Senate floor yesterday, which is great news. Tony has a very distinguished career, and I'm going to tell you a little bit about it, but I want to start with the fact that his position before he was nominated to be Associate Attorney General was as the Assistant Attorney General in the Civil Division. And it was my privilege to work for the Assistant Attorney General in the Civil Division when Robert Kennedy was the Attorney General. So that when Tony took that job and I went over to see him on an occasion, it was an absolutely marvelous feeling to walk back through the third floor of Main Justice and into that same office where I had worked. And that was a very special thing. He worked in the Clinton administration in the Justice Department. I now find out, I did not know, as special assistant to the Deputy Attorney General, who was my very dear friend Phil Hyman, many of you know, professor at Harvard Law School. So the plot kind of thickens. Very dear to my heart is the fact that Tony has chosen to have a framed picture of Robert Kennedy installed on his wall adjacent to his desk at the Justice Department. So, as many of you know, I worked for Robert Kennedy in the Senate for 4 years, and it's very special to me, Tony, that, as I've told you, that you have chosen to have that photograph there. Tony has a wonderful history, bio that is, I know, we're going to add to it. I hope maybe we'll get him back into ACS, among other things, after he's out of the government. But after working in the Justice Department in the Clinton administration, he was an assistant U.S. attorney in California and assistant attorney general of the state of California and lawyer litigator at Morrison & Foerster before coming back to the Justice Department this time. And many of you know, but others may not, that he married into a pretty terrific family, too. His wife, Maya, is the senior vice president of the Ford Foundation. His sister-in-law is the Attorney General of California. So Tony, that's kind of not just a power couple, but a power trio. Tony, it's just really very special to have you here to join us this afternoon, and I want to present to all of you the about-to-be Associate Attorney General of the United States, Tony West.
Thank you. Peter, thank you so much for that really wonderful introduction. And thank you for your friendship over these many years. One thing that Peter did not mention, it is absolutely true, I married up. And, but part of the benefit of that is that I have an absolutely wonderful daughter who was very involved in ACS at Harvard Law School, who graduated last year and is now clerking for Roy McLeese here in Washington, D.C., Mina Harris, who's here. And it's really a pleasure to be with you. I don't know what short straw I drew to follow Justice Stevens, but I have to say it is an honor to follow him to this podium, someone whose career I think really exemplifies two statues. If you come to the Department of Justice in the Great Hall, you'll find there are two statues, one that represents the majesty of the law, the other which represents law in the service of justice. I think his career exemplifies both of those quite well. And it's an idea that I know this organization, ACS, strives to make real in the work that you do in law schools around this country with law students, with lawyers and policymakers and opinion makers across this country. I can tell you that as the third ranking official at the Department of Justice, one who oversees the Civil Rights Division, one who oversees Office of Justice Programs and Access to Justice, among others, I am grateful for your commitment, and I'm honored by your invitation to be here with you today. This year is one in which we commemorate several important milestones in our continuing collective story to become a more perfect union. For if the arc of history bends towards justice, and I do believe it does, then it bends not by its own weight, but by the hands of those who dare to reach. And often, more than not, those hands are among the most humble. Earlier this year, we marked the 50th anniversary of the courageous march that John Lewis and so many others made across the Edmund Pettus Bridge, only to be greeted on the other side by state-sanctioned brutality. 50 years ago, this week, Alabama Governor George Wallace stood in the doorway of the University of Alabama in an ultimately futile attempt to block the integration of that university by two 20-year-old African-American college students, James Hood and Vivian Malone. Ms. Malone, who, in an irony of history, became the sister-in-law of the nation's first black attorney general. And this week also marked 50 years since Medgar Evers, a 37-year-old NAACP field secretary, organizing the effort to overturn Jim Crow in his home state of Mississippi, 50 years since he was shot in his driveway and died on his front steps. This year also marks a half-century since Clarence Gideon, a man described as a drifter, as a petty thief, won his case in the Supreme Court, which established the principle that our Constitution guarantees defendants in criminal cases the right to the assistance of counsel, regardless of whether that person can afford an attorney. Now, you ask just about anyone in this country, anyone who has ever seen a legal drama on television, whether or not they've got a right to an attorney, and they will tell you, yes, they have a right to an attorney, even if they can't afford one. This idea is so ingrained in our national DNA, it is so unremarkable to our contemporary ear, that many think its existence was inevitable and is universal. And yet we know that for too many Americans who are poor, neither is true. We know that for too many of our fellow citizens, to paraphrase President Kennedy, this nation, for all its hopes and all its boasts, has yet to fulfill the promise of Gideon's Supreme Court victory. 50 years later, in states and counties across this country, indigent defense providers labor under the weight of insufficient resources, crushing caseloads, and inadequate oversight. 50 years later, the vast majority of small county-based public defenders' offices don't have a single full-time investigator. And 50 years later, when resources are allocated to the criminal justice system, we know that indigent defense is too often left behind. In the federal system, budget cuts and sequestration have caused federal defenders to be laid off, furloughed, and left with the responsibility of providing effective representation without funds for experts, interpreters, and court transcripts. The situation is so dire that one federal judge has openly contemplated simply dismissing criminal immigration cases to mitigate the effects of public defender layoffs in his district. In New York, federal defenders requested a delay of the trial of Osama bin Laden's son-in-law because the federal defenders on that case are required to take furloughs. And in Boston, federal defenders handling the Boston Marathon bombing case, are facing 3 weeks of unpaid leave. 50 years later, these problems persist, as do so many others that you will hear about in the panel that follows this presentation. And yet, as serious as these challenges are, We cannot allow them to dampen our resolve when it comes to supporting indigent defense work because, as Attorney General Eric Holder so often says, fulfilling Gideon's legacy and ensuring that millions of Americans have access to the legal services to which they are constitutionally entitled, these are neither optional nor charitable propositions. They are central components of a fair and effective justice system that keeps our citizens safe and maintains its legitimacy in the eyes of everyone it serves. Supporting the work of public defenders is part of our mission at the Department of Justice. And that is why, not long after he assumed office, the Attorney General launched the Access to Justice Initiative, or as we affectionately call it, ATJ, an effort to help ensure that everyone can access their constitutional rights regardless of wealth or status. And with us today is the acting senior counselor, Deborah Leff of ATJ, and senior counsel, Karen Lash. She's also with us. Both of whom have been tireless advocates for strengthening indigent defense and who have been singly committed to the work of this initiative. And thanks to their hard work and the work of their colleagues, ATJ continues to engage a broad range of partners both within and outside the federal government to increase access to quality representation, to promote best practices, and recruit new allies to this vital work. And ATJ is just one part of what may be the Justice Department's most significant and sustained commitment to indigent defense since Robert Kennedy was Attorney General. Under Eric Holder's leadership, we have, over the past 4 years, committed more than $24 million in grants, initiatives, and assistance to support indigent defense and work throughout this country. This past March, the Attorney General announced another nearly $2 million in new initiatives for fiscal year 2013, efforts that will help us to build on ongoing efforts to help local and state communities improve the capacity of their indigent defense delivery systems and enhance their ability to provide quality representation to indigent defendants through our Answering Gideon's Call grants. Our work will continue to augment our work to enhance the quality of juvenile indigent defense representation. And we seek to assist states and locals with the implementation of innovative strategies that incorporate the ABA's 10 principles of a principal defense delivery system. This money will also increase our knowledge base about what's going on in indigent defense systems around this country. We don't know, for example, how many individuals in state court end up with a conviction because they jump to accept a plea deal without ever having the opportunity to see a lawyer who can help them understand the consequences of making such a life-changing decision. And gathering more data will help us improve service delivery. It'll also help us to increase awareness, and greater awareness, I think, is crucial because unlike most public defenders in this country, unlike most people in this room, most Americans, they don't fully realize the sense and state of crisis that we're in when it comes to indigent defense. Most don't realize that this crisis not only offends our sense of justice, but it's also economically unsustainable, as our failure to invest up front leads us to spend so much money trying to clean up mistakes in appeals, retrials, and inefficient, ineffective, and unnecessary incarceration. And we need data to be able to effectively tell this story. The commitment that the Department of Justice has made, I think, is also evident in the leadership personnel decisions that Attorney General Holder has made. For instance, I'm proud that one of our new additions to the Department of Justice is Bob Listenby, someone who now leads the Office of Juvenile Justice and Delinquency Prevention as administrator. Bob, as many of you know, was a trial lawyer at the Defender Association of Philadelphia, and he served as chief of its juvenile unit. So you know that when the issue of juvenile access to counsel comes up, Bob is going to ensure that it gets close attention at the Department of Justice. And yet, even though I believe our commitment is significant, our commitment to indigent defense is real, we know that it's not enough. And candidly, the efforts of the Department of Justice alone will simply never be enough. We know that the need is simply greater than that. We know that a fundamental impediment that cripples indigent defense systems throughout this country is the lack of adequate resources. That's just the fact. But we also know that given the fiscal realities that are exacerbated by the impacts of sequestration, we know that a strategy that focuses primarily on lamenting the lack of resources, that will yield limited success. So we must be creative in our approach. We must seek opportunities to recalibrate the machinery of our criminal justice system in ways that will allow us to enhance indigent defense, and while, yes, continuing to highlight the need for greater resources, recognize that there are worthwhile strategies apart from funding that we can and we must pursue to help us fulfill Gideon's promise. And let me share with you briefly 4 possible strategies. First, I think we must redouble our efforts to collaborate. Now, under the Attorney General's leadership, several U.S. attorneys' offices across the country have begun to regularly meet with federal public defenders and appointed defense counsel to address issues of mutual concern. And here in Washington, for example, the department has worked very closely with federal public defenders, with counsel appointed under the Criminal Justice Act, with judges to develop best practices for handling electronically stored information, or ESI, during the discovery process. And ESI, as many of you know, can present a myriad of challenges for an under-resourced, underfunded public defendant. The collaborative effort on which we've embarked has led to a new ESI protocol, which is designed to ensure that indigent defendants and their counsel have access to a potentially vast quantity of digital information in order to present their defense despite the shortage of resources that they confront. Collaborations like this are collaborations that we have to expand, such as through, as well as others, such as joint defense and prosecution training opportunities. And we also have to engage our state prosecution, defense, and judiciary counterparts, especially in rural areas. We can, where we can, we should share and replicate those collaborative solutions that we find are working, and we should encourage such collaboration at the state and county level through the appropriate use of our litigation tools and authorities at the Department of Justice. Second, we must augment efforts to integrate the indigent defense community in those critical decisions that allocate justice assistance grants, or JAG grants, and other criminal justice funds. See, we know from a 2012 GAO report that JAG grantees with indigent defense representatives as part of the fund allocation decision-making process, they were more likely to receive funding in indigent defense than those JAG grantees that did not include indigent defense representatives in their decision-making process. So at the Department of Justice, we're continuing to work to promote the increased representation of indigent defense community representatives by requiring JAG applicants to identify the stakeholders they are including in their strategic planning process. Third, we have to continue to consult. The Attorney General has repeatedly met with members of the Indigent Defense Bar, and he'll do so again at the end of this month. And later this month, I'll also sit down with representatives from the indigent defense community, along with Carol Mason, who is the new Assistant Attorney General for the Office of Justice Programs. We need to continue to hear from folks who are working in the field day in and day out as to how we can continue to make progress along this road. Consultation also means listening to indigent defense clients to help us better understand how to meet their needs, which is why I think it's important that some of the money we're spending to gather data about our indigent defense systems, it'll be used to better understand the client population, especially juveniles and those who suffer from mental illness, so that we can do a better job at meeting their needs as well. And finally, while we continue to examine our own enforcement authorities, we need to continue to look for opportunities to help ensure that the right to counsel is being upheld. Last December, for example, the department for the first time used its authority under 42 U.S.C. section 14141 to address constitutional violations in a juvenile justice system. Our Civil Rights Division entered into a groundbreaking agreement with the Juvenile Court of Memphis and Shelby County, Tennessee, that required the Shelby County Public Defender's Office to establish a dedicated juvenile defender unit in the Public Defender's Office that will be independent of the court and have the structure and resources necessary to provide independent, ethical, and zealous representation for children. And we're not stopping with Shelby County. We're not stopping with Shelby. In Meridian, Mississippi, we filed suit against the city of Lauderdale County, against Lauderdale County, against 2 youth court judges in the state of Mississippi, alleging that they are incarcerating young people for committing for minor offenses, including school disciplinary infractions, and are being punished disproportionately without due process of law. And among other things, our investigation found that children were making admissions to formal charges without being advised of their rights and without making an informed waiver of those rights, and that Lauderdale County does not consistently afford children meaningful opportunity or meaningful representation by an attorney during the juvenile justice process. So these efforts, I think, are important, but of course, even these efforts by themselves will not be enough. They're important steps that will help us fix our broken indigent defense system in this country. You know, one of the best films that I've seen this year is called Gideon's Army. Have any of you seen that film? If you haven't seen it, you should see it. It chronicles the commitment and perseverance of public defenders who are trying to bring just some shred of justice to individuals who are caught in this broken system. Their dogged persistence, I think, is an inspiration. It's public service at its best. And it reminds, I think, the rest of us that while these challenges are real and these challenges are hard, and even though everything that we do, even today, will not be a panacea that fully meets all of the challenges, we cannot give up. When you think about where Gideon's petition, his handwritten petition that he wrote to the Supreme Court, where it rests today, it's in the National Archives, along with the Declaration of Independence and the Bill of Rights and the Emancipation Proclamation. And I think if our American experience teaches us anything, it's that the struggle to make real those aspirational promises that are in those documents, that is an ongoing struggle and an ongoing process. That justice is as much a journey as it is a destination. It is as much a process as it is an outcome. And I think that so much of our work requires us to pay equal attention to both of those. So thank you for having me, and thank you for your commitment and the work that you do every day to help make real our constitutional promises.